And if the judges will please introduce themselves.
Hi, good afternoon. Glad to have you as our first team of the afternoon. My name is Michael DePiro. I'll be your lead judge for this round. Me. I am in Tallahassee, Florida. I work for the Florida Department of Education. Miriam?
You're on mute.
Hello, I'm so happy to be with you. My name is Miriam Memar Sadeghi. I participated in this We the People program the first year it was ever offered on the bicentennial of the U.S. Constitution a long time ago. I currently serve on the board of the Center for Civic Education, and I've spent a lot of my career providing civic education opportunities to people living in the Middle East, particularly Iran, where I'm originally from. So glad to be with you.
And good afternoon. My name is Tanya McConnell. I served for about 20 years as a professor of history at Columbia College in Columbia, South Carolina. Then a few years ago, I decided to do something more interesting, so I became a high school history teacher, which is what I'm doing right now in South Carolina, and I am honored to be with you guys. Well, We the People is one of the highlights of my year. You're from New Jersey, right? I spent a few months in New Jersey many years ago at Fort Monmouth, learning how to be an officer in the Army. That was I appreciate the hospitality the people in New Jersey showed me, not so much the hospitality the Army showed me at that particular time. But I really enjoyed my time in New Jersey.
So would you all take a minute to introduce yourselves?
My name is Alexandra Leck, and we're all students at East Brunswick High School.
My name is Maya Leventhal.
Hi, I'm Rachel Kiddo.
Hello, I'm Emily Dong.
Hi, I'm Jonathan, and this is our teacher, Mr. Monry.
Good afternoon.
Hi. Well, now that we all had a chance to know each other, I'm going to get us started with the formal stuff. We are interested in Unit 1, the philosophical and historical foundations of the American political system. The question is, Parliament passed the Habeas Corpus Act of 1679. What is habeas corpus, and to what extent, if any, is it essential to the principle of limited government? How has the writ of habeas corpus evolved in the United States? And under what circumstances, if any, might the writ of habeas corpus place an unnecessary burden on the government? And we'll start with Tandy with our first line of questions.
Let's listen. Oh,
They need to do their statement.
Oh, you know what? I'm so sorry.
We're all in that after lunch fog. Sorry, we'll get it together.
I'm telling you, it's lunch chaos. So
it totally freaked me out there.
I know, didn't I? So what we're going to do is I'm going to say, under what circumstances, if any, might the writ of habeas corpus place an unreasonable burden on the government? You may begin.
The writ of habeas corpus is an order that requires an official to explain why a person is being detained. It is essential to the ideal of limited government, as it protects against arbitrary executive infringement of people's liberties, embodies a system of checks and balances, promotes federalism, and assures rule of law. Habeas corpus grants incarcerated people protection of their due process rights, as it allows them to challenge their imprisonment when they believe they have been unconstitutionally detained. The writ also embodies checks and balances in post-trial petitions, as the judicial branch reviews the detainee's petition for a writ of habeas corpus to determine whether the executive detention of a prisoner is lawful.
However, it should be noted that the writ of habeas corpus alone has not appropriately limited the government. In the words of Attorney General Francis Biddle, the Constitution has never greatly bothered any wartime president. Executive Order 9066, for example, authorized Japanese internment without a constitutional suspension of habeas corpus, even though it blatantly denied American citizens of Japanese ancestry this right. The writ of habeas corpus has evolved in two main ways: pretrial detention and post-trial conviction. Pretrial detentions most commonly evolve when the court rectifies abuses of suspension, as seen in its adoption into the Constitution after British rule, the Ex parte Merryman ruling accompanying the Habeas Corpus Suspension Act of 1863, and the Guantanamo rulings following the Military Commissions Act of 2006.
Outlined as a grievance in the Declaration of Independence, Habeas corpus was adopted in the Constitution and could only be suspended with legislative power. Yet, the Habeas Corpus Suspension Act of 1863, which subsequently authorized President Lincoln's initially unconstitutional suspension of the writ during the Civil War, contradicted the suspension clause, as the power of suspension was later ruled exclusive to Congress in Ex parte Merriman. Pre-trial habeas rights were restricted again in 2006 with the Military Commissions Act, which prevented prisoners held in Guantanamo Bay from accessing habeas review. These restrictions were reversed in Boumediene v. Bush, which ruled that habeas extends to non-US citizens. Habeas corpus has also evolved to include post-trial conviction.
During Reconstruction, Congress passed the Habeas Corpus Act of 1867 to protect freed enslaved people in the South. The Supreme Court later interpreted this as giving detainees the power to use habeas corpus as a post-conviction remedy. Following this, the 1996 Anti-Terrorism and Effective Death Penalty Act introduced a notable change to post-conviction use, restricting habeas rights for convicted inmates by banning successive petitions by the same person. We believe that habeas corpus is essential. However, critics may argue that the writ places an unreasonable burden on the government, as it can severely impact national security when revealing key intelligence apparatus, ensuring due process rights, and capturing evidence on the battlefield, while inappropriately allowing the judiciary to second-guess the national security decisions of the president.
Sending the writ of habeas corpus to detainees might pose security risks to the federal government's intelligence gathering efforts. Dissenting in Boumediene v. Bush, Chief Justice Roberts argued against detainees' free access to classified information, stating its inevitability in fatally compromising national security interests. Justice Scalia highlighted the 1995 prosecution of Omar Rahman, in which names of approximately 200 unindicted co-conspirators given to the defense reached bin Laden within a matter of a few days. Justice Thomas also raises issue with the insertion of the judicial branch into matters of national security. In his dissent in Hamdi v. Rumsfeld, he claimed that courts simply lack the information and expertise needed to second-guess determinations made by the president in this area. Thank you.
Okay, now I'll go ahead and ask.
Andy, you got the floor.
Absolutely. Thank you so much. Wonderful presentation. It raises a lot of questions for me, so I'm just going to look at some of the details that you raised, and then we'll follow up on those. And I'm looking forward to this conversation. You told us that the Habeas Corpus Act, we began with the Habeas Corpus Act of 1679. What were the circumstances that lie behind the Habeas Corpus Act of 1679? What was going on that led Parliament to pass that law?
So prior to the Habeas Corpus Act of 1679, habeas corpus actually had a very different use than how we use it today. So we use it today to limit the government and protect people's individual liberties. However, in the past, prior to this act, it was actually used to give the executive more power. So the king was able to use this to question people and ask them why they were prisoning people. However, this act changed that and made it be something where the people were checking the executive instead of vice versa.
And specifically, it was Chief Justice Coke of the King's Bench that initially sort of derived this writ of habeas corpus from the due process protections of the Magna Carta. And so the circumstance in which it was passed was essentially, to be fair, a power struggle between Parliament and the King, and Parliament passed this to check the King. But that also showcases a very key difference between now and back then, because back then it was mainly meant to be a limited government concept where it was checking the King's authority. But now it's also a separation of powers concept where we're now having the judicial branch check the executive when the executive wrongly detains people.
Thank you.
All right, let me jump in there and ask you about, there's a lot that you said in terms of how this makes us vulnerable in terms of battlefield and with regards to basically national security threats. How do you think habeas corpus protections make us a more resilient and strong country? And think for a moment about China. You know, it's our chief adversary, extremely strong in almost every way, but they lack all of our political culture and our habeas corpus due process protections. Do you think that in this regard, we still have an advantage over them?
I think that at its base, there definitely is an argument to be made that habeas corpus makes us stronger because of the fact that when you have habeas corpus, you essentially have the basic fundamental principle that you can detain people randomly, right? And China does not necessarily have that concept. And so I think that while they may be potentially on the same pages as economically, I think that in the long term, the US Constitution, and it has stood for longer, will have a much more enduring life cycle because it guarantees these protections. And also, when we don't have these protections and we allow the executive to make decisions regarding who gets trial and who doesn't get a trial, we end up with a situation like in Russia where Vladimir Putin's enemies suddenly end up in jail or dead. And so that's kind of a very key protection in my mind.
Also, I'd like to expand on this by saying that having habeas corpus ensures that we have the consent of the people as well as a limited government necessary to ensure a properly functioning nation. So in China, for example, you can see cases of discrimination against the Uyghur people and other things like that really take away the voice of the people. But by ensuring habeas corpus, we make sure that we are acting in our public good, which ultimately allows the nation to run because it makes the people more willing to do things for their country.
And adding on to this, having habeas corpus, having proper habeas corpus allows for the natural rights of all the citizens to be protected because they're able to have a fair and just trial, as opposed to in nations that don't have habeas corpus rights, that don't allow for them to go through the proper proceedings of a trial.
So you talked a little bit about the evolution of habeas corpus, and we're in 2021. I want to look at the evolution of it and apply it to a modern context, but let's say limiting habeas corpus. Where do you see in modern times the constitutional justification to limit habeas corpus from 2021 and beyond?
I think with a rapidly advancing sort of threat, because I would say that, the biggest violations we've seen in the past are during wartime, right? We have Lincoln, we have Roosevelt with the internment, we have Lincoln with the suspension of Civil War, and we also have the entire War on Terror period in the early 21st century. So I think that the biggest category where we might see these suspensions happen, 2021 and beyond, is going to be in the area of war. Now, the issue is that I see these suspensions or these violations happening a bit more often because with the new fast pace of war, with the new methods of war happening nowadays, the executive might be tempted to really push for that leeway and authority to expand their influence and be able to detain people with less evidence because of the nature of how evidence kind of works in this digital world and so on and so forth.
I would have to disagree with John, and I would actually say that in modern day, I think the biggest reasons to suspend habeas corpus would be from domestic threats, not foreign, because I think throughout the events of the past year or so, I think we've seen from kind of both sides of the political spectrum serious social unrest, whether it be violent riots or Capitol riots. I think that we see a lot of domestic threats, and I think that these would be a better or more pressing case for suspending habeas rights in modern times.
I would like to take this actually in a slightly different direction. In response to the pandemic, governments have to, limit rights of the people in order to protect the public good of ensuring that this deadly virus is not spread. So in the case of New York, during the widespread George Floyd protests, the New York Supreme Court actually decided to suspend habeas rights in the interest of protecting people from spreading the disease. Now, I think going forward, we're going to look at issues that are a little bit more nuanced and different than war and go more into a broader definition of what public safety is and public security is and be able to protect that rather than just cases of invasion or rebellion.
So to that, Rachel, and actually all your responses, but Rachel mentioned the nuance and broadening. What if we're broadening what public safety means? What kind of checks can we have on a despotic government using limiting habeas corpus moving forward?
I mean, the best check on the government in limiting habeas corpus has always been seen with the judicial branch. Now, this was in the cases of the Guantanamo cases, where the judicial was telling the executive that they could not arbitrarily detain people by just calling them enemies of the state or enemy combatants. The judicial one has always been the one to really check the executive, and I think that should be what is used in the future. Thank you.
Add on what Rachel was saying, we can also look towards the Congress in terms of check towards habeas, as the Congress does hold the power to manage some of its lower courts, and thereby in an indirect way can influence these habeas petitions. And since as public health evolves and we have newer definitions of what rights are available, it's possible that we look towards Congress for guidance, where in previous cases, as in like Ex parte Merriman, where it's already been ruled that only Congress has the power for suspension. And going forward, we can look towards the similar terms to look at the limiting of habeas corpus.
Time.
Yeah, thank you. Very, very detailed and thorough responses to the questions. So we're going to spend some time and give you some feedback, and I'll get us started. I jot down some just keywords, however, yet add on to thereby. Those, when I hear those and then I hear substance after it, I shake my head yes, because those are those type of transition words that show you're building and you're getting to a greater depth of complexity in your answers. So I really like the use of those words, and then followed by substance. That was excellent. Also, it felt like a natural conversation. I don't feel like we were asking you questions and you're responding. I feel like we were talking to each other. So Tandy?
It was a great set of responses. We were asking questions and some, not trying to trip you up, but just trying to push the limits of your knowledge. And you kept pushing well beyond any reasonable expectations of where you ought to be. And you kept going and going and showing a depth of understanding that was just phenomenal. You guys are ready for law school.
I really agree. I mean, I just think it was a pleasure, it's a pleasure to hear you. I agree with my colleagues that it was a conversation more than anything else. And you also were not afraid to just combine your knowledge and facts with what your instincts and your own priorities are, and say what you think, particularly with regards to answering my question. Where are you guys going to be going to school?
I plan to go to Seton Hall, most likely. Yeah, in New Jersey. Yeah.
Cool.
Going to Brandeis.
Nice. Where is Brandeis again?
It's it's right outside of Boston.
That's right. Okay. Very nice.
I'm going to be going to Duke.
Wow.
Luckily.
I'm planning to go to the University of California, Irvine.
Wow.
Haven't decided yet.
Okay. Cool.
What's on your list? Rutgers? I mean, you're in New Brunswick. I'm figuring like Rutgers might be one of them, right?
Yeah, I think I'm probably not going to Rutgers, but I have lots of wait lists, so I might not know for like another month, but I have to commit somewhere else before I find out about the wait lists.
Well,
Oh.
They're the worst in the world. That's the worst thing in that world. I wish they never invented those.
yeah. Well, I'm going to turn it over to, did Ann? Oh, there she is. I was looking on your screen, like, did Ann disappear? We're going to turn it over to Ann and just wish you the best of luck.
Yes,
Thank you.
congratulations, and thank you guys for being here today. Good job.
Yes.
Thank you for
great
your
job.
time. Thank you so much.
Thank you so much.
Pleasure to meet you guys.